Mote Mungai for the 6th and 7th respondent.
In that event, I wish to draw your attention to the fact that there was a ruling that was delivered in this matter on directions by Chief Magistrate. That was on 30th of this month, where he directed that this matter to be mentioned before you upon service of the respondents. I wish to confirm that we did effect the service on all the respondents and there is an affidavit of service that we filed yesterday, the 1st of April 2026. I think pursuant to that service, all the respondents except the 5th and 6th respondents who are also served, all the respondents, and they have appeared except by counsel, except the only persons who have not appeared, Brendan Danny and Nicholas Kwak, the 4th and 5th respondents. And 5th respondents. I believe they are somewhere in England. They were employees of the first, or consultants of the first respondent. Then we served them through the email. We always corresponded with them. Rather, the first applicant corresponded with them. It is indicated in the affidavit of service. So we are here for only 2 reasons, very direct reasons. And already in the ruling, which I believe Your Honor has had the occasions to read.
Actually, I've just seen the file.
Oh, you've just seen the file? I can give you a copy. Yes. Or to figure out. I have I can give you a copy of the ruling? There is one. Okay. Yes, but the issue is direct, which we can summarize, is that at page 2 of that ruling, the Honorable Chief Magistrate gave directions with regard to 2 applications. That is, the main application seeking leave to prosecute is dated 5th of March 2026. Seeking leave for permission to prosecute privately, dated 5th of March 2026. Is a big application. I don't know whether it is easier to give you a copy of a physical application or we had not. It was filed online. So I'm only asking whether you may need a physical copy of the application. Yes, you bound it. It's a big one, so that's why I thought it might be easier. So Your Honor, that is the main application. There is also an application which was filed by Mr. Miller, who is present here, dated 23rd of March 2026. Mr. Miller, on 23rd of March 2026, alleging I have no right to practice before this court. It's a favorite application they file everywhere. Pursuant to that, we have filed a preliminary objection yesterday, which is on record. So having said that, towards the end of that ruling, the Chief Magistrate indicated that this court would still retain jurisdictions to give additional or alter the directions, to vary the directions that were given, including whether this is the kind of matter that should be argued orally or through written submissions, that is upon consulting the counsel on record. From our position, we wish to indicate that when we shall be filing our further affidavit after we have received the replying affidavit, we shall also file together with submissions. This is likely to be a long application, so it is easier to reduce the time to be taken in open court by doing the oral submissions. I believe everybody else has a right to file written submissions if they so wish, and therefore I would urge the court to give us a date. Given the time that was given by the court, it would appear to us that this date should be given towards the end of April or in early May, so that we are able to comply with those directions. We are most obliged.
Way to the 22nd of April, when certain documents, including note of appointment, responses, and so on, will be filed. As regards service, our only request to our landed colleagues, for the applicants, can you please be serving us with anything you're filing? We are on record for the first respondent, and there is no reason why you should continue to serve our clients directly. The notice of appointment of advocates was filed and served on the applicant's advocates. Therefore, please serve documents in accordance with the rules on us as advocates on record. There was mentioned by Landed Counsel for the applicants that the fourth and the fifth respondents have been served, but that they have not appeared. And let me just point out for the benefit of the court that according to the Chief Magistrate's directions, those respondents can file their appearance or notice of appointments by their advocates alongside their responses, which are not due until 15th of April. So we cannot presume that those respondents are not appearing in these proceedings. My proposal, my respectful proposal, Your Honor, is that because the timetable for that particular application by Mr. Kibe runs until the 22nd of April, and he says that he will file submissions alongside his further affidavits, my request would be that we take a mention date soon after the 22nd of April, late April or early May, as he proposes, so that you can then confirm compliance with all the directions. And even more importantly, with all the respondents, including the 4th and 5th, will have appeared. In my respectful view, it would be premature to grant a hearing date at this point before those housekeeping issues of compliance and appearance by all the parties are dealt with. And it is at that mention, Your Honor, that critical issues would be dealt with, like the written submissions by everybody else, like oral highlighting of those submissions, and critically, the order of hearing of the two pending applications, and in our humble view, the application by Mr. Miller challenging the validity of these proceedings would naturally and logically be heard first. I know a PU has been filed, that would be responded to, but I can state at the get-go that that PU does not could not possibly dispose of that application by the 6th and 7th respondent, but we will deal with that when we come to it. So kindly, in conclusion, Your Honor, just give us a mention date when we can come back on these housekeeping matters before we could get to the hearing of that first application dated the 5th of March, 2026. Thank you.
Yes, no, I can hear you, Your Honor. Thank you. Your Honor, first, I associate myself with the comments by my learned friend, Ms. Njoroge Rageru, Senior Counsel. But I have a few additional comments to make. First, Your Honor, if I heard counsel for the applicants correctly, he says that he effected service on the 4th and 5th respondent by email, because according to him, these were former employees or agents of the first respondent and so on. Your Honor, as we will demonstrate in the replying affidavit, that question of whether or not these were employees of the respondents is a hotly contested issue. And so, Your Honor, the question of whether or not in an application of this nature, whether service on the respondents can be effected through email, that's a significant issue that the court will have to deal with. And so, Your Honor, the question of the regularity of the service is a matter which I agree with my learned friend, Mr. Njoroge Rageru, should be dealt with at the mention that he has referred to in these proceedings. It must first of all satisfy itself that the service ordered by your brother, the Chief Magistrate, was effected in the proper and regular manner. And obviously, if it was not, then the court would not be able to take any step in the proceedings until that issue is regularized. That's the first issue. The second issue, Your Honor, if again I understood counsel for the applicant, he says that he has filed a preliminary objection. We have not been served with that preliminary objection, so we haven't seen it. But if indeed that is the case, given that there is an application that has been filed on which a preliminary objection has been filed, naturally, Your Honor, that then would be the first issue to be dealt with. The application on which there is a preliminary objection, because preliminary objection by their very nature, there is expectation that they must be dealt with and resolved before the court can deal with any other issue in the matter. And so, in my humble view, when we come back on the 22nd of April, I think one of the issues that we'll be dealing with when it comes to sequencing of the application, that's the view that we'll be taking, that the application by my learned friend, Mr. Miller, should be dealt with first. If the threshold question of whether or not service has been regularly effected is dealt with. The reason why we take up this issue, although we don't act for the fourth and fifth respondent, is simply this. The basis on which that service has been effected is the alleged relationship between those individuals and the first and third respondent. And it's on that basis that we will be taking the position that if service has been effected on the basis of that relationship, then we are entitled to be heard in demonstrating that that entire basis of service is wrong, and therefore the regularity of service, apart from whether or not you can serve by email, the regularity of that service is a matter that ought to be dealt with. So on our part, Your Honor, we will be happy to come back on the 22nd after the exhaustion of the timelines given for filing of responses, and then we can take further directions on that date. I thank you, Your Honor.
I wish to associate myself with Senior Counsels Jeroge Rigero and Senior Counsel Kamau Karori. Safe to add that the directions on service were very clear. Direction 3A, that each of the persons named was to be served within 3 days from the date of the ruling under reference. Your Honor, on my part, we're here for the fifth, sixth, and seventh respondent. But it is of great concern that the fourth and fifth, who are also mentioned in this matter, are neither here nor do they have representation by counsel. This being a criminal court, Your Honor, representation of the fourth and fifth accused persons is critical. And it is my humble submission that unless the said fourth and fifth accused persons are represented before you at the next hearing, then that in itself is an issue that must be taken up by this court prior to any other steps being taken. The second point, Your Honor, is that I have filed the application on behalf of the sixth and seventh respondent, which, by the very basis upon which it is premised, when the time does come for directions to be given on how to proceed, that application, Your Honor, must take priority over the March 2026. Your Honor, the purpose of this mention is purely to allocate a date to confirm compliance with the orders given by your brother, Honorable Onyina, and therefore we propose that a date be given in the first week of May, but we submit in closing that compliance includes evidence of proper service and representation of all parties before you on the next mentioned date. That's all, Your Honor.
We start with the fact that there is an affidavit of service indicating service in the manner that accords with the my learned colleagues who have spoken on this issue needs to make up their mind. They either appear for the fourth and fifth respondents, in which case they have a right and locus to challenge service upon them, or they don't. The Chief Magistrate ordered that all persons be served and indicate their lawyers, because we had a situation at that time where people who had not, whose clients had not been served had come to say they act for so and so. The same logic follows. We served everyone, including fourth and fifth, and there is an affidavit of service. Advocates for all these other persons cannot be able to speak on that issue. But Your Honor, this court if for whatever reasons considers that service is not adequate for whatever reasons, it can make an order for any other additional service. But the service to start with, since Mr. Karori has already spoken about the alleged relationship between the first, third respondents together with between actually the first to fifth respondents, the relationship between the first to fifth respondents, then the issue of the general policy under the Sexual Offences Act and the Employment Act, Section 6, on the issue of the relationships between an employer and an employee with regard to those issues would apply. So that persons associated with those persons who are employees or consultants cannot come and send the advocates here to say, these people have not been served. And on the other hand, the questions would be, now that people engaged in sexual abuse in your premises and you are aware, what have you done to ensure that they are before the court, to notify them? Because one of the charges against Diageo will be relevant, that they decided to sit back in the face of serious sexual offenses occurring while they were in charge of a construction project in Kisumu. So that I do not see how this helps them, where it goes, but service is a literal issue. The same way the literal issue about whether I can practice before your court. So let me come to the specific issues that they have raised. The proposals by my learned colleague Joroge Regero that for purposes, because this matter is an urgent matter, Your Honor, Diageo PLC, the first respondent, is trying to leave the country as soon as some approvals to sell shares to another group known as Asahi is approved. This is an urgent matter to us, to the applicants. We cannot follow that when the chief magistrates gave directions and left the issues of the date, you can start converting that to mentions. Your Honor, we have offered, we are doing submissions. Everybody else, they have not said they won't do submissions. We cannot be coming here to court to buy small installments. I urge you, the order on directions on submissions to be given to all councils. And a hearing date for the applications dated 5th of March. To be given so that it can be served together with further notification of the respondents. That's the only way we can comply with the requirement that of the Constitution, that matters be heard without unreasonable delay. And as regards the issue of this application by Mr. Miller, and particularly the preliminary objections that we have filed, you can give us a date, and we are willing to file our submissions of the preliminary objections within the next 7 days, so that we can get it out of the way. The PO is upheld, it's the end of the matter. If it doesn't, it will be heard on merits. So there is no single matter we are trying to run away from. But the essential thing is the nature of the proceedings and applications for leave to privately prosecute. We urge you to kindly give us that date so that we do not have to waste the court's time, including the victims of our offenses that happened between 2017 and 2019. Delayed justice is not good under our Constitution. You're most obliged.
He requests you, Your Honor, to make an order for submissions for all counsel to file submissions, and that you grant a hearing date for his application. With tremendous respect, that is not feasible, for the reason, firstly, that we respondents, he has filed those submissions, and going by the calendar, he has until 22nd of April to do that. So it would be wholly inappropriate and premature to order that we file any submissions before we have seen the applicant's submissions. Even more critically is a request for a hearing date for his application. It must be obvious to everyone by now that the application challenging the validity of these proceedings in their entirety has to take precedence. And yes, people will file submissions. There is a timetable that has been set, and in the fullness of time, the PO, the application itself will be heard. It is only if the suit survives, if the other application survives, that the question of a hearing date can arise. So an application now for a hearing date is completely premature, and the court should not entertain it for those obvious, practical, logical reasons. Thank you, Your Honor.
Your Honor, as I had intimated, we are in several court proceedings elsewhere dealing with the same group of advocates. Your Honor, it is common orders that are given every day. When the applicants are told, do your submissions by this date, the other side are told, do your submissions by this date. There is no contradiction. But if you are told, Your Honor, to start now to breach this, to fragment it, into let us see whether the applicant is going to file their submission, definitely we shall file it. It has always been the logic that it is done. It will be at directions of the court. And we are under an obligation to comply with that directions. So that I urge you to give directions that under Article 159 facilitates the expeditious disposal of the main matter and also the application that is a corollary attack on the main applications before you. And you have said we are willing to comply with the directions on both matters. But the only way that we are here and taking our time for today would be if there is meaningful business conducted today. So I urge Your Honor to give directions in a manner that assists this matter to move forward. And without coming to confirm, everybody is even actually senior than me. So are they saying that when they are served, they will not comply with the directions? I urge you to give directions that facilitates expeditious disposal of the matter. You are most obliged.
Your Honor, the purpose today, according to the ruling of your brother, Honorable L.O. Onyina, is purely to give directions to allocate a time once the timelines have expired. The timelines have not yet expired. The court here also indicated that you've not had the time to look at this ruling. So I think the best thing to do to save judicial time is just allocate a mention date, first week of May. Let him comply with issues of service. Let all parties comply as given in the directions therein. Then after that, you can come before this court. But for now, Your Honor, anything beyond giving directions in terms of a mention date for compliance would be completely contrary to the ruling that was given by your brother. That's all, Your Honor.
No, let me. I have given tentative directions. The magistrate who will hear this matter has a right to modify, alter, or add anything that assists the matter to progress forward.
when we complain that this matter has not been moving forward, and you're immediately having everybody saying, give us a mention date in May. The mischief is obvious. I urge Your Honor to have this matter to proceed on an expeditious manner. You have full authority. And this presumption that there is no proper service, they have to choose whether they speak for Brendan Daly and Nicholas Quack. And the court still has the jurisdiction to say how, if any need be, any additional service should be effected. You are most obliged.
I will kindly request you
Yes.
to allow me to peruse this file.
Absolutely.
Every application which is here,
Yes.
including the ruling, that was considered the ruling. And since tomorrow is a public holiday, I can give you next week after I have perused.
Yes, that's clear. Give us a minute.
You can come back next week so that I can give my direction
Yes.
based on my understanding.
That is absolutely not.
Sentence which my landed senior has asked me to highlight to you, and it appears at page 4 of the ruling, just at the bottom. It says, the trial court's discretion to alter or vary any directions given herein is not, in the course of managing the case, fettered in any way whatsoever by these directions. So that then the trial court will also determine how to handle the two applications already on record and on the manner of disposal, whether by oral submissions or written submissions upon hearing stroke consulting the counsel on record. So basically, what the other courts did is, in its opinion, it said this thing because of the urgency, because we addressed the issue of urgency at length, and Mr. Miller was present. And the court said, for us to move forward and very fast, let us do this. But the court may appreciate more urgency and give such directions that the matter can be heard more expeditiously. So our request to you is that in the course of altering those directions, make such directions that will even make the disposal of these applications even faster. Let us not elongate the period. It can clearly be seen that the suggestion of there being a hearing date is causing a lot of fire on the other side. Let us bring this matter to a close, and let us not litigate by way of installments. Let us have just one direction that will dispose these applications. That's all.
Therefore, the court will have to peruse the file and give further directions. So I think I mentioned that I'll give my directions, that is next week.
Could we do it on Wednesday, probably then in the afternoon, so that we can be finished with the other matters?
Sorry, on Thursday, all the lawyers in this matter have another related matter on Thursday. I think that bit might be a bit complicated.
We would support the Wednesday date, 8th of 8th.
You know, can we try that 11 a.m. if we can't get a date, either Wednesday or Thursday?
I think Friday is okay.
At 11 a.m.?
It is 10.
10.
What time, Your Honor?
What time do you?
11 a.m.?
Mr. Miller?
11, Your Honor.
11. Mr.
I have difficulties on Friday, Your Honor. I'll actually be out of town Friday the 10th. Is it possible to do it on the following Monday the 13th, kindly?
Actually, the 13th is when, on my record, we have a case with them. Your Honor, these directions, Mr. Regero has already indicated there will be Matangani. I believe the directions is the court reading that this is where I want us to go. Each advocate here is assisted with an assistant. I have Ms. Mosongo, Kiraguaduta. There is nobody appearing here alone. What will the associates be doing if they cannot come to listen to directions being read? There is no substantive issue that is happening. Mr. Regero had indicated we can come on Friday so that we avoid this thing, because it's the same game over and over again, to take the furthest date that it is possible.
Mr. Kibe, you will note from the directions the court urged you to exercise decorum in these proceedings. The client has a right to representation. You can see this is a hotly contested matter. A simple mention, because of all this, has taken quite a bit of time. It is important that I'm there with my colleague, and that is why I'm requesting, and this is a usual reasonable request, for Monday 13th. If you have said you have difficulties on the 13th, then we can come Tuesday, anytime, and we'll dispose of this matter.
You know, I concede, let's come on Tuesday.
So let me give you time. I can say Tuesday. Can we do it at 2 p.m.?
Yes, yes, it's at 2 p.m. Tuesday, 2 p.m.
Tuesday the 14th?
14th, yes.
2
At 2 p.m.
14th, 2:30. I am most obliged, sir. Thank you very much.
Something else, Senior Counsel, I think also I should disclose is that this facility that we have here
Yes.
is a shared facility.
Okay.
So if we are able to be here physically, it will be okay. Because we might find another court. Because this is a shared facility with shared other courts around. So if mentioned on 14th of April at 2.
At 2.
At 2.
Most obliged.
2 or 2:30? 2 or 2:30, Your Honor?
Even 2:30 is okay. Actually, my understanding of criminal law is that it must be in open court. If there is a serious question of legality of online proceedings.
So mention on
We'll endeavor to be in open court, given your comments, Your Honor.
Thank you.
Thank you. Have a good day, Your Honor.